We are about to start in a couple of minutes. I'm sorry, we had a technical issue. Yeah, I hope everyone can hear me now. Hi, Prashanthi Garu, how are you doing? Hi, Prashanthi Garu, can you hear me?
Yes, sorry. Yes, I can.
Yeah,
I'm good, thank you. How are you?
I'm good. Sorry for we had a technical issue. I'm very
problem.
sorry for that. So yeah, let's it was a it was a very great week. Everyone is having a roller coaster ride here, and today we are hosting a show with Prashanthi Reddy Garu from Prashanthi Reddy ESQ. She has experience of over 15 years in this.
20 years actually, 23 years.
Over 23 years of experience, and I just want to give an introduction about. I'll start with the attorney. Attorney, could you please introduce yourself, and then I'll introduce about IF, and then we can start.
Sure. As Ranjit just said, my name is Prashanthi. I'm an immigration attorney based out of New York, Manhattan, and I have been doing this for the past 20 plus years, since 1997. So, and I mainly my expertise is in business immigration, so it's labor certs, I-140s, H1s, L1s, and we also do family-based immigration. So yeah, that's what I do.
Okay, 1 second. I think there's a. I don't know what happened again. Just.
This service is provided.
I hope everyone can hear me now. Yeah, I think we are good now. Sorry again. So let me just start with. Can everyone hear me now? Hello. I hope everything is fine now. Can everyone hear? I don't know why, what's happening. Just a minute. I think we are on now. I think everything should be fine. Can everyone hear me now? Hi, Prashanthi Garu. Can you hear me?
Yes, I can hear you.
Goodbye.
Everything fine now? So, yeah, I think everything is good now. Yeah, everything is good now, Prashanthi garu. Sorry again. Let's start the call again. Let me introduce Prashanthi Reddy garu from Prashanthi Reddy ESQ, and she has over 23 years of experience. And we are hosting today call with the IF Immigration Forum. Let me just give you an overview of IF before I proceed. And then we can take the introduction of the attorney. Immigration Forum is a national grassroots level advocacy group working on to bring fairness in high-skilled immigration in this great country of United States of America. We understand that the visa bulletin updates or changes are not going to fix our fundamental issue, but it helps a lot of backlogged individuals. In this show, we wanted to bring awareness and help answer questions to many deserving members who got lucky and who deserve it. Thank you for the Immigration Forum. Let's take the introduction from the attorney. Hi, Prashanthi garu. How are you doing? Can you please just introduce yourself and then we can take it from there?
Yes, my name is Prashanthi Reddy. I'm an immigration attorney based out of New York, Manhattan. I have, as Ranjit said, over 20 plus years of experience, and I specialize mostly in business immigration, and we do family immigration as well.
That sounds great. So yeah, last week has been a roller coaster ride, and I mean, a lot of things happened, and there are a lot of confusions among people. So let's start this, by at least see and answer questions what are all possible. Now, the basic question everyone has in mind is, what is the filing date and the final action date? Could you please throw some light on what is the difference between those two, and how USCIS considers the dates, and how the process is, and then we can take a lot of questions then.
Yeah, so basically there are two. Every time there's a visa bulletin, there are two charts in the visa bulletin. One is the final action date, and one is the dates for filing. And usually they follow the final action date. But usually every October, from October to March, when there becomes more availability because the new fiscal year is starting, they follow the dates for filing. So basically dates for filing is USCIS's way of saying that they have availability, so they have the bandwidth to take more 485s at this time. So they're allowing people to file 485s even before their date becomes current. It's like an artificial process that they have in place because they know that the processing time takes, a certain number of months. So they are allowing you to file in advance before the your visa number actually becomes current. So the final action date is your actual visa number becoming current, which means that, if that continues for a few months until your case is processed, you'll actually get the green card. But this allows you the dates for processing table, which has become current now for a lot of you, allows you to put your foot in the door, right? So it allows you to file your 485 application and get all the benefits that you get with a 485. And also, allows you to, get your EAD and your advance parole and become independent from H-1B if you would want to. And also, there's much more independence with reference to changing employers. So it's a golden opportunity don't miss it, because we don't know when this is an unprecedented movement, forward movement in cases. So we don't know when this will happen again, or if it will ever happen, unless there's some change in the law. So yeah, don't miss this opportunity. File before October 31st.
Cool. Lot of questions in mind for the people, especially, who now that EB3 has gone too far and EB2 is behind. Now people are considering for downgrades. So let's, this is a question, I hope you are swamped with calls last 2 days at least.
Yes, yeah, absolutely. There's no time. I have been up until 1 a.m. and then working on the weekend as well. So yes, from the last 2 days, that's what's been happening.
Yeah, even the other sad news I just want to say is the SPB Garu. So, the legend of India.
I just heard that. That's really sad. I didn't know he was sick.
Yeah, he sang about 40,000 songs, and I think no one in the world has sung, and that's again, shocking news. But I just want to say, wherever he is, he rests in peace, and he will live through the songs that he sung, in all the languages. To start with, so yeah, now the question is about the downgrades. So let's just start with the basic question: is there any harm in doing a downgrade, or no harm and you can just try it, or what are the chances of getting an approval for a downgrade, or do you think you should do it or you should not do it? Can you just throw some light?
In my opinion, you have no choice. You have to do the downgrade, because then you will lose the opportunity and you do not know when this will come back again. So, I mean, in my mind, there is no choice here. You have to do it. And if everything goes well, you will be successful and the I-140 will get approved. If you're not, then you would have at least tried. So basically, there is no disadvantage except for the disadvantage of losing the money, which is quite substantial. I understand that. The 485 fees, the attorney fees, and the I-140 fees. That's your disadvantage. You're losing that. The advantage is huge. You're able to file a 485. Now, if it gets denied, then yes, your 485 will get denied. Your I-140 will be denied. The chance of it getting denied is mainly for the ability to pay, because all other issues have already been sorted out because your I-140 was already approved. Unless it was approved by mistake last time, they can always, re-adjudicate it. But the main issue, I think, is the ability to pay, because now they're going to look at whether your employer has the ability to pay from the time that the I-140 was approved to the present. And so many things could have happened after that, after your I-140 got approved. Suppose it got approved in 2015. We're talking about, 5 years since then. And also with the present COVID situation, most employers are incurring a loss. So if your salary is equivalent to the prevailing wage, I think there is no risk. I mean, there is no chance of getting a denial there. But if it is not, and there is a gap between your prevailing wage and the actual salary that you're being paid, then the tax returns of the company are looked at to see what the profits are or what the net current assets are. And then if they're able to meet that difference, then it'll still get approved. So yes, you're taking a chance, but it's worth it, I think. Now, so that's the only disadvantage, that it might get denied and you might lose your money. Now, there's another thing that people keep on asking me, what happens to my EB2? Can I again interfile at some time in the future? I think that question is even moot at this point, What are you going to do if I tell you your EB2 is lost? Are you going to not file now? What is it? What choice do you have? So I think you shouldn't be asking these questions even. And you should instead expend your efforts in getting your documents ready, talking to your employer, rather than, getting into a state of coma where, or paranoia where you're thinking, what happens to my EB2? What can I interfile? I'm getting so many questions like that, and I'm telling them, I'm answering wherever I can, but I'm telling them that, look, you need to focus on things that are important.
Don't think too much.
You can't, because what if I tell you that the EB2 is no more? Are you not going to do it? See, that's the bottom line, So,
and even if EB2 is there, let's assume you have to again refile everything, right?
even if EB2 is there, is it going to become current tomorrow?
Let's even
That's
assume
the main question.
Yeah, let's say
So,
even if it has become, I think you have to refile everything again, right?
So yes, I should answer that question because it's been asked. Though it's moot, I think it's moot at this point.
Yes, true.
I should still answer it because so when you file the EB3 amendment, the EB2 does not get affected. So so you have two I-140s really. You have the EB2 I-140 and you have the EB3 I-140, unless they change something in the future. As of now, that is what the regulation is. You can have two I-140s. And in the future, if EB2 does become current, yes, you can interfile. Again, that is what the regulation is as of now. If they decide to change it in the future, no one can say that. They can change whatever they want to. So I don't, whenever I say, don't quote me on this and say, oh, but you said, it can be done. Why can't it be done now? So yes, there is a procedure to interfile the EB2 with the EB3. You simply have to write to them and ask them to do it. And, we have done this in the past and so have other attorneys. So yes, that procedure exists as of now.
So it doesn't involve filing I-485 and all again. It just
no.
Okay. So that means, let's say by any chance, if filing an action, final action dates become current, there will be a chance of interfiling if USCIS still allows them. And now no one knows what happens, and USCIS behaves with this downgrade thing because they might have a lot of influx of applications, and they might
huge influx, because not only are the EB3s filing, the EB2s also are filing.
Yes, that's
because everybody is doing an amendment to downgrade.
Yeah, the downgrades may result in heavy influx of applications, and USCIS may issue RFEs. They may approve, they may deny. No one knows, but I've been saying the same thing. It's once in a lifetime opportunity, and it's a golden opportunity. Use it or lose it.
You have to take it. Lose it, yeah. Use it or lose it. You have to take that. You have to take that.
In the last 8 years, been here and have never seen something like this. It happened, I believe, in the last in 2007, and it may never happen again.
Right, and we were discussing this, right, Ranjit, even before what the dates will move, and we were not expecting it to move so far.
Yeah. We thought EB2. Actually, we thought the vice versa. EB2 will move more, and EB3 may not move because rest of the world EB3 is not current. So they will take their share, and that's what we thought. But then I don't know how the allocation was done. But anyway,
and we don't know moving forward also in November, December, what will happen until March. Because I mean, if you look at the visa bulletin and if you look at the bottom of it, it says what to expect, and that's an unusual paragraph even for them to have, because they never have that. It says what to expect, and it says rapid forward movement for EB2 and EB3 India. So I really don't know what that means and how they can have a rapid forward movement after all these applications have been filed. So, it's all puzzling. But we have to presume that it will not exist beyond October 31st, and we have to file our applications accordingly.
Yeah, and before I just want to I want to read the disclaimer. Please note that this live show is not to provide any legal advice. It is very general in nature, and it is only for informational purposes. Immigration Forum or the host is not responsible in any way for your actions. Use the information at your own risk. If you need a legal advice or a legal consultation, please reach Attorney Prashanthi Garu at 212-354-1010, or you can reach her at our email, Prashanthi, PRASHANTHI @reddyesq.com. And you can shoot her an email, and she'll be glad to answer any questions, or be part of your filing and help you out. And I know I've been seeing her from quite some time, and she is very economical, and you can definitely rely on her. And anything related, if you need your employer to get in touch with her, you can just say that to your employer, and you can reach her. That's what I wanted to say. And yeah, there are a lot of questions again, EB2 to EB3. So the other question a lot of people have is, especially people who move to other employers. Now, few employers have withdrawn the I-140, few have not withdrawn the I-140. Now the question is, can someone go to previous employer where the I-140 is already withdrawn? What's the process? And what if not withdrawn? Can they downgrade? Can you answer these questions?
Yeah, so there's many complex questions around that, and there's so many callers so many people who have called me who just resigned like a week ago and they don't have a new I-140, or a few days ago, and there's somebody called me who resigned like on Friday. So it's just, it's just the whole situation is very unique. But if you have to go back, what if you have an approved I-140 with the previous employer and you don't have anything with the present employer, if you want to take advantage of the situation, you really have to go back. There is nothing much more, to say other than that. I mean, there is a lot to say, but with reference to this point, you have to go back to the previous employer, ask them if they are willing to, sponsor you for your green card, or continue to be willing to sponsor you for the green card. So if they have not withdrawn the I-140, then it's the question of the ability to pay. So you have to, you don't want to just blindly again file your I-140 and 485. I mean, you may want to, because, it's a matter of losing some money, but you have to have at least some idea as to what is the approvability of your case. And to do that, you really have to talk to your employer and find out, what their tax returns look like since your I-140 was last approved. So, for example, if your I-140 was approved in say 2018, so from 2018 to 2020, you have to find out how they've been doing, and if their tax returns are showing a profit. The reason that we have to look into this is because you're no longer on their payroll, and I don't think there's enough time really to get back onto their payroll and then file, because you'll have to file a H-1B transfer again. So that's something you need to again work out. You just need to file the transfer. It doesn't need to be approved, and you can get back onto their payroll, but not sure if there's time enough for that. So if there isn't, then you have to file as a future job offer, and then again you have to show that there is the ability to pay, which means that the employer should show the ability to pay your prevailing wage as per your labor. And since you're not on their W-2, it has to be the entire prevailing wage. So it's not like the actual wages paid can be deducted from the prevailing wage, and then they just have to show the balance in their tax returns, in the profits. They have to show the entire amount. So if it's 100K prevailing wage, they'll have to show that they have either net current assets or a profit of 100,000, in the last 3 years, if your I-140 was approved 3 years ago. That's what USCIS is asking for. And in the minimum, they'll ask for at least the present year. And if they're filing several petitions, the employer, they will ask for all the employers put together. All the petitions put together, they will ask for a list, and they will ask for the ability to pay. So this is something that you at least need to be aware of, and then make a decision as to whether you want to file or not. If they agree to, then you can just file the I-140 485 for future employment. Once you get your EAD, it would be a good idea to join that employer, work for them for at least 6 months, because after that you're allowed to change your employer based on AC-21, right? Now, if the employer has withdrawn your I-140, as they should be doing if you leave, then you have to refile the I-140. You can always remember the labor cert is always valid. It's in perpetuality. It doesn't expire. So you can refile that I-140 and then do a concurrent I-140 and 485 filing. If you need to downgrade, again, if you need to do both, refile because it's been withdrawn, and downgrade, you can do both of them in the same amended petition. So you can refile and refile it this time in EB3. So whatever needs to be done can be done. So that's the story with, going back to your old employer.
Is there any need of filing prevailing wages, or you said perm is not needed, so nothing is needed, not even prevailing wage? Correct. So it's just, they have to, because the I-140 was withdrawn, they can use the copy of the perm and they can just file an I-140 if it's EB3 already, or if it's not, then they just have to downgrade it. One question here a lot of people have is, I believe there is no premium. Can you just confirm if there is a premium for this downgrade process?
No premium.
Okay, so there is no premium for these downgrades. Now one other question is, a lot of people have I-140 that's already pending with USCIS in EB2, let's assume. Because it's pending, can we request USCIS to do it in the EB3?
You don't have the time to do that now. You have to file a 485.
Yeah,
so
I know,
you can only You can only, what you need to do in that situation, Ranjit, is you have to refile the I-140 in EB3 and concurrently file it with the 485. You cannot do, you cannot submit the receipt of the I-140 and file it and submit the 485. They will not allow that.
Yeah, what I'm asking is I-140 EB2 is pending with USCIS. Can we just ask them to downgrade it?
No, that will not be useful. Then you cannot file the 485.
Premium, I mean, there's a premium, right?
Oh, if there is premium and if it gets approved before October 31st, yes. But the better way of, and it will not, because it's now going to be 2 weeks, but it's going to be 15 business days. So that will be 20 days. You have no time to do that. That is not a good option. The better option is to while that other I-140 is pending, you refile your I-140 in EB3 and concurrently file your 485. With reference to that first I-140, you can withdraw it or leave it as it is, do whatever you want with that. But for now, that's what you need to do.
Okay, sounds good. So that's another option we have. So everyone, it is always good that, if you have an EB2, try to downgrade. Now, the other challenge is to convince the employers, especially the MNCs and, public listed companies are $1 billion companies. They don't understand. Especially, so what do you think? How do they try to convince them? It has to obviously go through the employee, but then, do you have any points, how to convince them or how to at least give it a try?
You mean convince them for the downgrade?
Yes.
Yeah, so I have been receiving a lot of calls from Cognizant employees and Infosys. And yes, these are the issues. So basically, with reference to convincing them, one thing is the fees, right? If you're presently, if you're still working for them and they are your employers, the reason most employers wouldn't want to do it is because of the fees. Now, the I-140 fees is a gray area. I don't want to say that it's okay if the employee pays it, but it's not at least like the labor cert, where the employer has to pay it. But in the past, when the employee has paid it, there have been instances when employers have gotten into trouble. So that's kind of like a gray area, but that could be one incentive, one way of convincing them. The second problem that MNCs have is that if they have a mass downgrade and they have hundreds of applications that are being downgraded, they will not get approved unless then they'll have to show this ability to pay issue is there. But of course, it's easier when the employee is already working for them, but there will still be a difference between the prevailing wage and the wage that you're paying. So it'll be like they have to support and be able to support, all these downgrades. So if you do it, and even if the employer allows you to, it may or may not get approved. So that's something to keep in mind. But of course, you should try. Most employers, again, don't want to do it because they'd rather their employees be on a H1, unfortunately, rather than, get onto a 485. But actually, if you look into it, especially for the MNCs, for them to file extensions, file amendments, going forward, they'll have to pay that $4,000 fee, even for extensions. So that's one way for them to avoid that fee, right? Because if you're not on a H1, then, they don't have to pay the fee for their future cases. It's only the H1, depending on how many people they have on a H1. So that is an advantage, something that you can bring to their notice that, it's actually an advantage for them. And then other ways, maybe by promising them that you will stay. Most of them are afraid that, as soon as you get the green card, you'll leave, or as soon as you file the 485 in 6 months, you'll leave. But you have to tell them that, look, even if I'm on a H1, I can still leave you. I can still file a transfer. It's easy. So that is not something that should stop them from filing. So these are the points I think you can talk to them about. If you're happy with them, basically, you will stay with them at least for 6 months or more, and that should be sufficient enough reason for them to file.
Yeah, and other thing is, it's always your word against their word or their word against yours. So everyone these days, a lot of people are suggesting that, a lot of attorneys have written blogs and articles. You can just send them, so that gives the credibility that they can be sure that the downgrade is possible and that something can be considered.
Right, right.
A-
Of course,
and
the first thing is they have to be convinced that it's possible. I'm
yes,
presuming they know that it's possible, but after that, even then they may not be willing to do it. So
yeah.
I guess,
And
yeah.
the other way is, a lot of people know or don't know that you can the I-485 filing and all the fees can be borne by the employee. Employer is
Correct.
not
For the
responsible.
485, absolutely.
Yes,
I-140 is, yeah.
especially yeah. I mean, for the downgrade, I-140 fee is not. I don't think it's significant. I think it's $700, I believe.
Yes, it's not much. Correct.
Yeah. So other than that, all other fees can be paid by the employee. So you
That's
can
correct.
assure them that they don't have to pay, and you can pay it from your pocket, and that's one way of convincing them
Correct.
that this is possible. And a lot of people have the question, like, once this I-485, 145, I-485 is filed, what happens if the H-1B is rejected? Can they stay legally?
Yeah, that's the magic of the 485, right? You're not dependent on your H1 anymore. You don't have to worry about going to the consulates for visas anymore and getting, stuck there if you don't get the visa and losing your status in the US completely, not being able to come back to your job. So it opens up all these windows for you. Um, you can, if your H1 gets denied for some reason, you can still remain in the country and start working immediately on your EAD, or you can even give up your H1 if that's what you choose to do. But please make sure you do that after your I-140 gets approved, not before,
Yep.
because then the whole package can just get
So
denied.
can they work when it is pending? Let's say H-1B is denied and I-485 is pending. Can they work legally?
Yeah, if they have an EAD approved. So
No, not up. It's still
we have to
pending.
file. Yeah, you said 485 pending.
Yeah.
So then you should say EAD pending.
Yeah.
So
Let's say, yeah.
If EAD is pending, obviously you can't work. You have
So,
to
but
wait
they
for the
can at
EAD
least
to get
stay. But
approved.
they can at least
Yes,
stay in
they
the
can stay
country
in the country. Correct.
until the
Absolutely.
EAD is approved, and then they can take it
Then they
forward.
can join their work back.
And what is your suggestion on keeping H1 as well as the EAD both? A lot of people say it's better to keep both if you have a chance. Do you have any
There's no
suggestion?
harm in doing that, and you can again, you don't have to go to the consulate for a visa. You can travel on advance parole and still continue to be on a H1. So that is a unique thing that is allowed, and you can still continue to maintain your H1. The only thing you cannot do is you cannot start working on EAD and then switch back to a H1. But you can travel on advance parole uh, and not travel on your H1, but still continue to be on a H1. So that's an important, I think,
So if
something to
there is a
understand.
possibility, it's better to keep both until you get a green card.
There's no harm.
Yeah. And
Unless your employer is, finding it difficult, or you need more flexibility
yeah.
with reference to changing jobs. Yeah.
So once the 485 is filed, the whole packet, let's say the downgrade 485, I-765 and I-131, which is advanced parole. So if, let's say, an employee lost a job, so it's 180 days, right? Can you just explain that thing? So, people are assured that if something happens, the other employer can still continue from there.
So this is an offer of future job. It's a future job offer. People get confused about that. This is not saying, they're saying that you have a job now. So if you lose your job, but the employer, or you're laid off because the client, you don't have a project with the client or something like that. But if the employer has not withdrawn the offer of employment for the future job, they're saying after you get a green card, you will join them. That's the thing. As long as they have not withdrawn that, you can still continue to be on a 485. If you're within the 6 months and you can't change employers. If you can change employers, then you should do so and get a new offer of employment by filing a new 485J. So that's the process.
So after 180 days, they can switch employers and they don't have to do all the process. They just have to do I-485J supplement. The new employer has to just take it from there. Does
Correct.
it impact any processing times, let's say, because of the switch? Does the processing time increase? Let's say if it was supposed to be approved in 6 months, let's say, because of
The
the switch.
485 will not be approved in 6 months anyway. It is just sitting there.
And
So the
let's
processing
assume,
time.
yeah, I know. Let's say the EAD, they're
The
still
EAD
waiting
by
for
then
the
should
EAD.
already be approved. I mean, 6
Approved,
months is a long
okay.
time. So it
Okay.
shouldn't affect.
Okay. Let's say, for instance, because of the wait times, maybe if EAD is still not in hand, but they still
I
have
don't
an
think
option.
I don't think it should be affected because it's a seamless process.
True, true. Oh, yeah. And what do you think, because of this lot of influx of applications, do you see the wait times increasing significantly for, let's say, the downgrade or to get an EAD, or
You have to
what do
presume
you?
that, yeah. I mean, it's logical. I mean, to presume that, especially with USCIS furloughs, that all that will take time, but we don't care about that because you obviously have to maintain your H1, as I said. At least if you're doing both until the I-140 gets approved, or if you're just doing 485 until the EAD gets approved. So as long as, why do you care how long it takes? Really, that's again a moot question. It's just like the other questions that they're asking, but I understand the anxiety. But in general, it's a moot question.
Okay. I just want to tell the callers that we'll start taking calls in 5 minutes. Just be ready. Meanwhile, I have a couple of questions. Let me just ask them, and then we can take calls exactly at 10:30. Now it's 10:25 a.m. I'm talking about PST. It should be 1:25 in the EST. So I'll just taking calls in 5 minutes. Before that, I have a couple of questions. So yeah, other issues everyone now having is, now that the dates got current for almost everyone. Before 2015, they are doing downgrades and all. They are thinking about the birth certificate now. This is $1 million question now. So what is, so a lot of people don't have birth certificates. Some have birth certificates. Some have certificate, but what really matters, the date of registration matters, or the issue date matters for the birth certificate, and what happens if there is no birth certificate. Could you please explain that?
Right. So yes, the birth certificate is as important to the 485 as your degree is important to a H1. So that's the importance of the birth certificate. So luckily, sometime back, they came up with USCIS came up with a memo saying that 485s could be rejected if the basic documents were not there. They'll just send them back from the mailroom. But they went back on that, and they decided to postpone it. And luckily for us, unless the only reason it could be sent back is if the forms are not filled out properly, if they're not signed, if the check is incorrect. These are the only reasons it can come back. Having said that, it doesn't mean that we should file skeleton petitions. We shouldn't. So we should, in our offices, we file a complete application and try our hardest, no matter what the constraint of time is, to, submit a perfect application to the USCIS, because we want to avoid RFEs, because those are unnecessary complications to get an RFE. But I understand because of the constraints of time, there are some documents that will be missing. So with reference to the birth certificate, for those who don't have a birth certificate, I mean, usually you should have one. For people who are applying now, the age group that is applying now, most of you should have birth certificates, because they made it compulsory to register births and deaths in India. So you should have it, but for some reason, if you do not, then I guess first thing you should do is try to get it. As I said, I don't believe in filing incomplete applications. Try to get it, contact the birth and death registry from where you were born, get your relatives to call them or whatever it takes. And you should get a non-availability certificate at least. So a non-availability certificate is basically saying that, your birth was never registered. Or you can get a presently issued birth certificate. So they'll give you a new birth certificate registered as of today. But in both instances, in addition to this, you will have to submit secondary evidence. The secondary evidence is 2 birth affidavits. Pretty much they'll be saying from someone who was present at the time of your birth and who's alive at the time of your birth, so someone older than you. Preferably your uncle or aunt or parents, that would be preferable. And the birth affidavits are basically on stamp paper if they're in India, or notarized on white paper here if they're here. And they're saying that we were present at, my name is so and so, we were present at the time of the birth. This is the time and date that they were born. And this is the relationship that we have with you, whatever your relationship is. So that's the format for the birth affidavit. You need two. And in addition to that, secondary evidence for birth would be, for India, would be school leaving certificate. So a transfer certificate that all of us should have from our 10th grade. So that's another document that is acceptable. If none of these are there, there are other documents. These are primary documents that are, always better to submit the best form of evidence, and this is the best form of evidence. Now, I do, even though I've said that you should go back to and get your non-availability, get it presently registered. I know it's not possible in every instance because of the way the government itself works in India. They will not process anything, and it's, to be fair, it's very short notice for them to do anything. So no matter how efficient, it may not be possible to, get it done. In that instance, I would just submit secondary evidence at this point, and then you will get an RFE though. And I will submit, then we would just, once we get the RFE, submit the birth certificate or the non-availability certificate. So that is the process, for the birth certificates.
Given the time,
there are many instances also, Ranjit, which I wanted to point out, and I know there'll be a lot of questions, and I'm hoping to answer as many so that when the callers come, we can just say that, look, we've already answered this question. The lot of instances where birth certificates do not have names, because you know how it is in our culture. We don't name the child until the 21st birthday. So there are a lot of instances where they will not have names. So in that instance, you will have to have, along with the birth affidavit and the language that I just mentioned, it also has to say that the birth certificate does not have the name, but it belongs to so and so. So that additional language is also required. And there are often instances when the names are misspelled, or only there's first name instead of last name. Only one name is there. In most instances, there's only the first name. In that case, it's fine. If there's just one name, the first name is there, it's enough. Sometimes there's a misspelling of the name. We will have to explain that if they send an RFE that the name has been misspelled. I don't think we should highlight that at this point.
Yeah, what if the date of birth is wrong? That's another question a lot of people have.
Then I can't even submit that birth certificate. If it's wrong, then you have to get it corrected before I can even submit it. So I will not submit it because that will cause a lot of confusion.
So because the problem is in India, especially the date of birth is consistent from SSC or the 10th. So in 10th, a lot of mistakes happen. They misspell the names. Sometimes the date of birth is a typo, which we don't know until we get the certificate. So if there is a typo and in the date of birth especially, so it is not valid at all. So you have to get another birth certificate or affidavit.
Yeah, you have to get a corrected birth certificate, and there will be an issue in the sense that there will be an RFE. It's not like the issue cannot be tackled, but there will be an RFE and it has to be addressed.
And is it only for the primary applicant, or all the applicants should have these birth certificates?
All the applicants should have all the documents. It's a separate 485 application for each applicant, and the requirements are exactly the same for each applicant, even for minors.
Yeah. Another question is, because of the time constraint, a lot of people may not be able to get it on time. So what do you suggest to them? Just file it for now and just keep trying for them?
Yes, you have to file it for now and immediately reach out to the authorities and get what you need. Because you don't know when you'll get the RFE.
Yeah, the same with the medicals. So are the medicals mandatory, or if you don't have time or something, you can just leave it for now and just submit?
Again, same answer. I would prefer that you do the medicals, but if you're not able to get it done, we will submit without, but you will get an RFE.
Yeah. I mean, at least, you don't want to lose this time frame, because we don't know.
Absolutely. You will not, I will not hold it for medicals, but I suggest you get it done. So we have a good application.
Yeah.
A complete application. If you can't, because I understand that even the medical practitioners must be busy. So it's possible that you may not be able to get it on time. Yes, absolutely. Then we will file it without.
Another question here is, what happens, let's say they filed the adjustment of status, I-485, 765, and everything is pending. and let's say they have to go to India for an emergency, what happens? That's a critical question everyone is asking these days.
So if you have a visa, a H1 or a H4, you can come back on that. But recently there has been some resistance to that, and I don't want them to get into trouble. In the past, the rules seem to be that if it's a family-based petition, none of these are family-based. They're all, we're doing all employment-based. We're talking about employment-based right now. That's what the bulletin is about. But if it's family-based, you cannot leave the country without an advance parole approval. If you do, then your 485 is considered withdrawn and it gets denied. But in employment-based cases, they would always allow people to come in on their visas, and it would not, the 485 would not be considered to be affected in any way. But since the present administration has come, I have seen some posts where they have caused trouble, where there's been an issue, and there's AILA has asked to clarify this question again. So I would take an attorney's advice before I do that, basically. Before I
just wanted to know, because a lot of people asking, if let's say there's an emergency, can I go and come back? Does it impact the processing of that spending?
At the time that you need to travel, you should speak to an attorney and get their input, because every day the situation is changing. So I don't want to give you some advice now, which may not be applicable to you at the time of traveling.
So, I mean, in terms of the petition being pending, that will not be affected, but the entry may be affected. That's what you mean, right?
No, I'm saying the petition itself will be affected.
Okay, that could be. So just take an attorney advice if that's the case.
Correct.
Another question a lot of people have is, let's say the husband is here and the wife is in India now. Now in this situation,
that's unfortunate, actually.
How do they file? Is there
because they can't file.
File?
That's why. Okay. And we're talking about family separation again, and they can come back on a H4, sure, but the husband will have a green card and the wife will not.
What's the process then? When are they eligible to file?
They can only file again when the priority date becomes current.
I mean,
I'm cannot file until then. So I urge you, whoever, like for example, I had a caller and they said, their spouse is outside the country. I'm like, okay, ask them to come in. They're like, they cannot because they have COVID. So they have to wait for at least 2 weeks, and then to be symptom free, and then another 2 weeks after that. So there's so many unique situations where the family members are outside the country, and either they don't have a visa or they can't come in due to some constraints. But if they can come in, it would be ridiculous not to, because you have to come in and you have to file a 485.
If there is a possibility, please come. Now
please do come.
Let's start taking calls. The first call I'm going to take here says Abhishek, ending with 7501. The number is 313-318-7501. Abhishek, you are online. You can ask your question. Abhishek, can you hear? 7501 ending number. The number is 313-318-7501. You are on call. Can you ask a question? Okay, let's take another question. The next question will be Raju here, the number ending with 5402. Do you have a question? Hello?
Maybe their questions were already answered, I'm hoping.
Okay, let's take another question. I'm just curious. So I have another question here, which we got from Facebook. So what do you think still people should downgrade even though if the date is not current, or only people whose date is current should do a downgrade?
That's actually a good question. I think they should wait. If it's not current, they should wait. There is no necessity to downgrade now. You can always downgrade once it becomes current, like a lot of people are doing now.
Okay, and what do you think about the movement in the coming days? Do you think there will be a movement, or USGS still will be accepting filing dates, or they can go back and say filing final action dates? What do you think about it?
We don't know, and I don't want to speculate. But only thing I can say is that
Anything can happen.
Anything can happen, but you should file before October 31st, unless October 15th you get the November visa bulletin and it says that it's still current.
Okay. There's another caller. Let's see if we can hear. It says Srinivas, a number ending 4746. One second. I don't know what's happening. Yeah, just go ahead and ask your question.
I can't hear it.
Previous employer, and with the current employer, it's like is still in the early stages, like wage determination process.
The host would like to.
Go with my previous employer and file a H1B transfer and start.
Okay, his question is he has an EB2 EB2 with the current employer, but he's asking it's not current. So he's asking if it is possible to go to the previous employer and downgrade.
We, I think, discussed that, and we talked about the advantages and disadvantages of doing that, and we talked about the ability to pay issue, right?
Okay, 1 second. I don't know. Okay, let's go for the next question. Ravi, ending 8299. Yeah, I can hear you.
Yeah, I can hear you. Okay. Yeah, my question is actually my date July 2013, but my H1B got denied in December 2018, so I had to move to H4EAD. Currently, I'm on H4EAD. My wife is working, and her PD is EB2 August 2014. So, if I want to move to my previous employer, can I directly file? Because mine is July 2013 EB3, and can I file my I-485 directly, or do I have to again go? Because I'm working with the client directly, but I can go back to my current employer and the previous employer with whom I have the prior to date 2013. So do I have to again do my H1B and the labor and everything, or can I directly file I-485?
Okay, the question is, he has an I-140 with the previous employer. He's just asking now if you have to go back, do they have to file everything again, and they can just file, or they can just file 485?
If you have an I-140 approved already, and if it has not been withdrawn, you can just file 485.
Yeah, if the I-140 is withdrawn, then you should the employer should again file the I-140 along with the 485 concurrently, right?
Yes.
I think there is some problem in connecting the calls. Okay, I'm just checking on my phone rather. Okay. Okay, Abhishek, are you? Abhishek, are you still there? Abhishek ending 7501. Okay, the next call is Tirupati ending 6591.
Hi, I have a question about my 140 is approved in Bulletin. Now my employer is added to downgrade and he asked me to go ahead and proceed. The only question is my wife is on passport, but she was out of status, so we filed for extension on our book. So is it possible to file 485 as well now?
Prashanthi, the question is, his wife is on H4, but because they missed the filing or whatever, they have filed the NPT, non-pro-tunc. Now he's asking whether he can include the wife because she's technically, the status is not, kind of known.
Good question. I think he should. It might get denied because, as of the date of filing, you have to show that the dependent was in status. But I think you should give it a shot. And if the non-pro-tunc case gets approved, then we're hoping that that H4 approval will be backdated, so there won't be any gap. Also, maybe 245K, 245K cannot help with if an I-94 is not valid. It is only for other status violations. So, I mean, the only thing I can say is that I think you should file it and then the only thing that will happen is that it might get denied because you don't know what will happen with the non-pro-tunc case. Let's hope that it gets approved.
So because they anyways have a receipt of that, just use that receipt and just file it for now.
Correct. Yeah, I think that's the best option for now.
The next call is the number ending 0501. Whole number is 469-594-0501.
Hi, Prashanthi. I have a quick question. So I have a 140 with my previous employer and I'm not with them anymore. So they're asking me to come on to their H1. I mean, they're trying to put a H1 transfer for me in order to file 485. So the question is, can I still be with my current employer even if they filed the H1 transfer and then start processing 485?
Yeah, the question is he has a I-140 with the previous employer and he's insisting to join them to file a 485.
So join.
Yeah, so he's asking when the H1B transfer is in process, can he still continue with the current employer and previous employer still files H1B transfer as well as 485?
If he's giving you an opportunity to file the 485, then you should join them because it's easier to prove ability to pay. So really, I don't know what you're trying to do. There's no purpose in filing a H1 transfer if you're not on the payroll. So, my answer to that would be to join them as soon as you possibly can and file the I-140 for 85.
But the question is kind of like, is it okay to still continue with the same employer and still file with the old?
How can you work for two employers? It's not a concurrent H1.
Yeah, I mean, H1 transfer is in process. It's not approved.
Correct. But then you should decide. Remember, we had this question even before.
Yeah.
You have to decide which employee you want to work for. You can't work for both. It's not a concurrent H1. You're filing a transfer. So you can only work for one. And it would make sense to work for the person who is filing a 485.
Yeah. The next caller is Gupta, ending 1806.
Hi, thank you. Hi, Prashanthi. My question is that I have my 140 approved with the previous employer, and I moved to a different employer last year, and they just filed the form.
There's a lot of echo and disturbance.
Okay, let me tell the question. So he's asking his previous employer is still ready to file, but his question is, I mean, he's not asking to join them, but he's still ready to file a 485 or I-765 and all. His question is at any point of time, is it mandatory for him to go back to him, or,
Yes. Once he gets the EAD approved, he should go back and work for that employer.
So is it mandatory that they have to work for some period? How long do you have any period that they should work for?
You're only allowed to change 6 months later. So I would not change until I've actually worked for the employer, because your whole green card could be in jeopardy. So I would work as soon as I can, basically. Either I would work on a H1 or I would work on a EAD before the 6 months period. There is no specific period of time. I would just work as soon as I possibly can. So there are no questions asked. And once I'm able to file the 485 Js after 6 months, then I would move to a different employer.
Okay. So other question we have offline is 1 second. I'm just pulling the questions. So once they get EAD, can they switch the job? And what does the employer have to do when they have to switch the job at some point of time? Where do they start?
In order to change your job, you have to file a 485J, and the employer needs to sign that.
So no need to go through the whole process of filing again anything. Just the I-485J is filed, and you still get to keep whatever it is in the process.
Correct. Yeah.
Going back to the birth certificate thing, in case of non-availability of the birth certificate, especially for the people who are born, let's say, about 1975 or below, so what do they have to get? There is another birth certificate thing that consulate gives usually. So is it valid? And if it's valid, do they have to supplement anything with that, or how does it work?
The consulate birth certificate will not work. You have to follow the instructions that I gave earlier with reference to the birth certificate. Consulate birth certificate will not work.
Okay, just a minute, Prashanthi. I think we lost the call. I'm just trying to connect.
Can you hear me?
You're muted, Ranjit.
Oh, sorry, I'm muted. You can go ahead. Yeah, sorry. 8293, number ending 8293.
My name is Abhishek.
I can finally hear you.
So,
Yes.
Prashanthi, thank you for answering all the questions. Very helpful. My question is, so if we concurrently file I-140 and 485, right, in the downgrade, when does the 180 days, stop for EAD? Like, for example, so can we switch employers? Like if we file 140 downgrade, it won't be approved for 4 months, and then there would be much time for EAD approval. So is that a composite time of 180 days in the petition after which we can switch employers, or we have to wait for EAD like to be pending?
Okay, it has nothing to do with EAD at all. EAD is not in the picture. AC21 regulation is with reference to when you file the 485. So it's 6 months after the 485 is filed, provided you have worked for the previous employer. It doesn't make sense to do it otherwise. Then you can switch for and do AC21 after the 6-month period.
Prashanthi,
So I will quickly so in my scenario, I have worked for that employer for 8 years and I switched to another employer. So now when I go back and downgrade.
No, you should, it's not about working earlier. After filing the 485, you should work.
Oh, but what if that's what my question is. So you filed 140 downgrade, that cannot happen in premium, right? And it will take 4 or 5 months at least.
Nobody cares about the I-140.
Or like,
no one cares. No one cares about the I-140. The issue is, when was the 485 filed? And 6 months after that, you can apply for AC21. But before you do that, it is prudent to actually work for the employer. You can work on a H1, you can work on a EAD, whatever it might be. Without working for the employer that actually files your green card, do not further transfer your case.
Okay, but still, I'm not convinced with the answer. Like my question is 140 filing. Suppose I file October 31st, right, on an I-140 downgrade. So my EAD would not be processed until my EB3 I-140 is approved, right? So, and then let's say 7 months elapse in that. So can I file supplement J on that time or no?
No, you cannot. You can, but your green card will get denied eventually because they'll say that you never worked for the original sponsor. If that's what you choose to do, that's up to you.
No, his question is technically if let's say I-140 downgrade with I-485, everything is filed together, can they still move after 180 days or, is
Yes, they can, but you're not understanding my point. If you move, you can technically move. But if my point is that if you move without working for the sponsor, then you will have problems. Because you have never at any point worked for the sponsor after filing the 485.
Yeah,
so please understand what I'm trying to say.
We cannot see you. Is it? Just wanted to.
Yeah, I will. Yeah, it's done already.
Oh, okay.
So as long as it's understood, you understand my point.
Yeah, I understood. So yeah, next caller is Pawan Manikonda, ending with 1034. You are on the air. You can ask your question.
Hi, Ranjit. Hi, Prashanthi.
Hi.
Taking this call. Can you hear me?
Yes.
Yeah, sure. So it's just based on the previous question. So after 180 days, after downgrading or working with the current employer with whom I've downgraded, when I shift to the new employer, so I'm currently on EB2, so I'm going to downgrade to EB3 and I'll work for this current employer for 6 months. And after 6 months, when I move to a new employer, can I come back to EB2 if the queue moves fast? I mean, like, what can I do? I mean, like, one is that, and second thing is like, should I move on EAD or H1B? Should the H1 ever be alive in this case?
So the most important thing you have to remember is whether it be H1B or EAD. Before you actually file the transfer, you should have showed that after filing the 485, you work for the employer. That is my main concern.
Right.
So whether you get whether you do it on EAD or you're not able to do it on EAD because EAD is not yet approved and you do it on a H1, whatever you do, important that you work for the sponsored employer. Once you have done that, you've started working and you've done that and you work for a sufficient period of time, then my suggestion is to, if the 6 months is over, then you can do the AC21. Your second question is with reference to downgrading, upgrading, that is a different story. You have to start now and you can figure that out later. Who knows what will happen with your EB2. But if interfiling is there at that point, then you can interfile.
I mean, this is going to be with the new employer, though. So employer A, I'm going to work for 6 months. Employer B is going to only join on EAD or H1 again. But I'll have, I mean, like to go to EB2 again from EB3 with the employer B after 6 months. Is that a possibility at all?
It might be.
Okay.
Yeah, we'll take the next question. So, yeah, we'll answer the question and we'll take next one. Wait, Pawan. So his question is, you know, let's say when he's moving back to another employer, can they obviously will file I-485 supplement J. Along with that, can they also interfile is the question.
Yeah, I understood the question and I said it might be.
Yes, okay, that's a question.
I understood.
Prashanthi,
so,
still we cannot see you.
Okay.
Oh yeah, now we can see you. Yeah. So we are taking the next question. Bala, ending 8766. The number 8766. Bala.
Hi, Prashanthi Garu and
hello.
Ranjit, thanks for this time. So my quick question is, I think the follow-up question to the previous one. So my previous employer holds my I-140 in EB2 and he's ready to change it to EB3. But my question is, can I hold until I receive my EAD to switch my job? I can continue working in my current job until I get my EAD and then switch, or
yes, you can. You can do that. Yes,
H1
you can do that. You can do that. That's up to you. Yes.
Okay, that sounds. And also, just a follow-up question. You mentioned about concurrent H1 filing, right? So, is it possible that a concurrent H1 can be filed with the previous employer, if at all there is a chance? Is that something that we can consider, whoever is in this boat?
Concurrent H1 is always possible. So out of the context of the 485. So yes, it's possible to file and work with two employers at the same time.
Yeah, his basic question is like, you know, if he had concurrent filing, he can work for both employers, and you know, he also be happy that he filed 485 and then.
Yeah, you want everything under the sun plus the 485 plus the green card. You know, you guys have to realize that this is an opportunity. You either take it or you leave it, and you're. I don't know. It's. I think you know you have to. Look at the gift that is given to you. And not overanalyze things and waste your time. First, file it. Okay. First, focus on filing your 485. Then attorneys will have plenty of time to answer all the 100 questions that you have. At this point, if you are paralyzed with your questions, you will not be able to file. So I think rather than talking to me now, what you should be doing is talking to your previous employer, calling him right now, and taking those steps. Rather than thinking of all the possible questions that you can ask and then figuring out what to be done and what is not to be done. I'm seeing this not just with you, but this is my genuine advice to everyone.
True.
Because I'm getting so many phone calls. Like now I must have gotten at least 50 phone calls while I was on this line with you guys.
Yeah.
And it's the same thing. Everybody is in paralysis.
Yeah.
You know? So it's analysis paralysis right now.
Yes. And everyone, please keep in mind that
filing the 485. Then in November, whatever questions you have, you can go ahead and ask your attorney those questions.
Yes. Everyone, please keep in mind that this is again a golden opportunity, and please use it. and do whatever you have to. Let's say if you don't have a I-140 with the current employer, go back to the previous employer. If he insists you joining, just join them, because you don't get this opportunity. So whatever you have to do, just do.
And you can figure that out later. You have 6
Yes.
months to figure that out.
Yes.
You know,
And
so don't, get bogged down by
yes.
everything, all that other things now. First file.
Yeah. And
Get your
don't
documents
even
ready. Yeah, I think.
don't even worry about switching this after 180 days and all that, because that's the future scenario. You may switch, you may not switch, you don't even need it. And until and unless it's needed, just stick with the employer and get a EAD, work for some time, and then think of those things, because don't make things complicated, moving back and forth, and be in a position where you are not here, not there, not anywhere.
Right. And in any case, like Ranjit said, we are only trying to help you guys, so don't misunderstand. So in any case, you have time to think about that once you have filed. Right now, you don't have time to breathe also.
When
so
you have that situation, then you can deal with that situation.
You can deal with it. You have time to think calmly. Attorneys will have time to answer your questions. There's plenty of time for that.
Yeah, we'll take next caller, Sudha, ending 2609. Sudha, ending 2609. You are on air if you have any question. Sudha, ending 2609.
Hi. Can you listen me? Can you hear me?
Yes, we can hear you.
Yeah. My question is, I'm with my same employer for so many years, and they're happy to downgrade, and I'm downgrading and applying in this October month. For example, if my EB2 is approved 140, in November or December, if my 140 that comes in filing status, then should I file another 485, or same 485 will be upgraded to? EB2.
So I think we're having repetitive questions. We're having repetitive questions on the show. We should try and avoid that. But I will answer this question because we can get more questions that will benefit, the larger audience as well, and make use of our time, because we don't have too much time left. Yes. But yes, you depending on what the situation is, then nobody can guarantee you interfiling, but it's possible as of now.
Yeah, interfiling is possible. If you want to again switch back to EB3, EB2, whatever it is, there is always interfiling available based on that situation. So don't worry about it now. We'll worry about it later. For now, just file. We'll take the next caller. Kalyan, ending 8245. Kalyan, ending 8245.
And no one is going to ask us questions. They're going to be afraid to ask us any question.
No, you can always ask a question.
Yes, please go ahead. We'll give you our comments, whatever question you ask.
Yeah, short question and a short answer if it's already answered. Kalyan, 8245 ending.
Yes.
Hi.
Thank you for taking my question. So I have a question, like maybe it's related to my current employer. I'm with the current employer on EB2. And I want to just know whether if they are not willing to downgrade. So is there any possibility that I can do it from outside, or how is it like?
No, you cannot.
I have just I-140 documents.
Very sorry, but you cannot. There's nothing that can be done.
So there is no self-filing. It has to go through the employer. So you have to convince them. If they cannot, then there's nothing anyone can do.
Okay.
Yeah. Next question is Anand, ending 8661. Number ending 8661.
Hey, hi. Are you able to hear me?
Yes.
Okay. My previous employer, I got 140 approved. I'm planning to go with them for my 485 applying. But at the same time, my current employer, I'm still pending with my labor. My question is, what happens if both of them file my 485? Let's say my previous employer filed 485 and my current employer also filed.
How can your current employer file without an I-140 approval? So that's not possible. So there's no question about, the answer is moot. Question is moot. You can only file through your previous employer.
Okay.
Okay.
Before
Okay.
proceeding to
The previous employer, EAD approved. The moment the EAD is approved, I should joining them, right?
Yes. The sooner the better.
Yeah, the next question. Before next question, I just want to again repeat the disclaimer. Please note that this show is not to provide any legal advice and it is only for informational purposes. Please use the information at your own risk. If you have to reach Prashanthi Garu, please reach her at 212-354-1010 or prashanthi@reddyesq.com. You can also visit their website www.reddyesq.com. So feel free to reach her or give the contact to your employer and let them know if you need any services. So the next question is from the number ending 7172. Number ending 7172. I think it's not. Okay, the next question is from number ending 8265. I think it's a New York number, 8265.
Hi, Ranjit. Can you hear me?
Yes, you can. Yeah, go ahead.
Thank you, Prashanthi, for taking my call. And my question is me and my spouse both has EB2, I-140 approved. And right now, I'm trying to downgrade my EB2 to EB3. So if I put her as a dependent on my I-485, is she be able to maintain her EB2 on her own, or that's going to be get cancelled or rejected or something like that?
The I-140 remains. Her I-140 will remain.
Okay. Her I-140 will remain until what status we reach until we upload a EAD, or until what time her status will be
The I-140 will remain until somebody withdraws it.
Okay, got it. Okay, so I can.
Yeah, we are taking the next question. Raju ending 5402. Raju ending 5402.
Hey, hi, Ranjit and Shanti. Thanks for the call.
Yeah.
So
go ahead.
I'm 19 days short for the EB3 to be correct.
Very sorry to hear that.
Okay, so what is the best suggestion on this, Prashanthi?
You just have to wait.
Suggest? Wait until November bulletin and see what happens. No, just keep.
Yeah, that's
don't
the
close
only
your hope.
thing.
Keep waiting and watching.
Oh, okay. So until then, we need not to file anything or
downgrade,
right?
You can't do anything, but just keep all the documents ready just in case. That's the only thing everyone can suggest. So, date of birth certificate, whatever, just keep them ready. The next question is Bala Reddy Maram, ending 3384. Ending 3384.
Hi, good evening.
Yeah, go ahead.
Thank you for the call. Just a quick question. My I-140 is approved to my previous employer, and now I'm with the current employer. We haven't filed a form, or I don't have any I-140. What is the paperwork that the previous employer is willing to do my I-485? What is the paperwork that is entitled to them?
You have to file I-140 again. You have to file the I-140 again. So you need the paperwork required, whatever is required for an I-140. And of course, you need the paperwork that's required for I-485.
I have I-140 to the old employer. They haven't revoked it yet.
Yeah, well, let attorney answer the question. The thing is, he's asking, what do they have to do? You cannot self-file. Employer has to do. So reach out to the employer. If they are willing to file it, then you can proceed. There is no concept of self-filing. You cannot self-file anything. It has to go through the employer. Employer has to sign certain documents and provide certain documents related to employment. So it's not that you can do it yourself. So
thank you, Ranjit.
Yeah, again. So the next question is number ending 9752 and number ending 9752. Number ending 9752.
Hi, can you hear me?
Yes, yes.
Yeah.
Okay. A quick question from my side. So my I-140 is approved. This is for EB1 category, and my L1 is an extension. So am I eligible to file I-485?
Yes, absolutely. Please file it ASAP. You just put your receipt. Submit with your receipt. Hopefully your L1 won't get denied or anything. But even if it does, you're still filed because you just have to show as of the date of filing you are in status.
Yeah.
And that receipt really gives you the status.
Okay. Next question. Srinivas ending 0759. Ending 0759. Okay, let's take another. Prashant ending 0554. Prashant ending 0554. Prashant ending 0554. 732-850-0554. Okay, let's take the next call. And another thing, I'm not sure when you joined, if you have joined late and whatever, the live will be on the Facebook, the recording will be on the Facebook. You can just refer it later. And again, if you have to reach the attorney, you can always reach her, at www.reddyesq.com or prashanthi@reddyesq.com, and you can utilize the services. Meanwhile, next call is Gopi 5052. If you have a question, be quick. We don't have much time. Gopi ending 5052. Gopi ending 5. Okay, I'll take the next one. Bhaskar ending 040. Bhaskar ending 6046. Bhaskar 6046.
Hi.
Yeah.
Hi. Thank you for the opportunity to ask the question. So for 485, my employer is willing to file and downgrade. I have a question about my birth certificate. For all the passports I have at May 23rd as the official one, but my Water Municipal Corporation, they gave me with the 22nd because it was late night, so they just gave 22nd. So what should I do to show that it is 23rd, not just 22nd?
You have to get your birth certificate corrected. So in the meantime, just submit secondary evidence and then get your birth certificate corrected. And when there's an RFE, you can submit the corrected birth certificate.
Yeah. Since you cannot correct all the documents, the only way to correct is the birth certificate. So just try rectifying that. Meanwhile, apply with whatever you have. The next caller is Chandrasekhara, ending 3944. Please be quick.
Hey, Ranjit. Yep.
Yeah.
Hey, Ranjit, can you hear me?
Yeah, please go ahead.
Hey, Ranjit and Prashanthi, thanks for taking time to answer the question.
You're
my
welcome.
name is Vijay. I'm from Ohio, and my situation is I'm on H1 with a full-time employer, and I have a EB2, and my wife was an employee of a private firm a few years back, and she had her EB3 in 2013 April, and she's currently on H4 EAD. She's not working because she took a break after having the kids. So when I spoke to the employer 2 days back, he was saying that if I can go with my employer to downgrade and go that process, but I was checking with her employer as well. And he was saying that she needs to be on H1 before they can file the 485. Is that true?
No.
Which is not right?
Correct. It's not true. As long as she's in status, she can
Thank you.
file and she can work. Immediately, she can get onto the payroll if she's on H4 EAD. So she's in a good situation if you want to do. The only issue is what the tax returns of the employer are. So that's, I think, is the main question is, in order for you to decide which to do, you have to look at which company is more financially viable and then make your decision based on that. I think that's the most important.
Yeah, as long as you are in status, you can file, right? Just
yeah. So the H4, anyway, again, if your wife already has an EB3 approved and the I-140 is already approved, you don't need to downgrade. So, you don't even have to look at the financial status of the employer because that's not a question anymore because you're not filing an I-140. So actually, that's
better.
That might be better.
Yeah. The next question is Rajesh. Rajesh ending 9956. Rajesh ending 9956.
Hi, can you hear me?
Yes, please go ahead.
Okay. So I have I-140 approved with my previous employer, I'm working for my current employer, and perm is filed, and I-140 is in progress. I just filed a couple of months back, but not premium. So it is in progress. So my question is, while it is in progress, can I apply new petition for 140 and 485?
Right, that's what you need to do. You have to file a new I-140 in EB3 and file concurrently with 485. So you're filing for a second I-140 based on the same labor cert. That's the only way to do it.
Okay. The next question is number ending 4702. Number ending 4702. It's a Phoenix number. Number ending 4702.
Hi, thank you, Prashant and Ranjit. Okay, thanks for taking the call.
Yeah, go ahead.
My previous employer, I had with my EB3 and I-140 approved with previous employer. Recently, only last week, my term got approved. Is it like, I'm not sure like on what basis they choose whether it's EB2 or EB3 during I-140, or they can file directly EB3 category because my previous...
Yes. So the answer to that question is, if the perm is approved, you're in luck. You don't have to go to the previous employer. File with the present employer, port the priority date, apply in EB3, the I-140, and concurrently file for the 485.
Okay. The next call, Ram, ending 9799. Ram, ending 9799.
Can you hear me?
Yeah, go ahead, please.
Yeah, so my question is, I think Prashanthi has answered this a lot of times, but there is a little bit different. Like my old employer, I have approved I-140 with my old employer, and my priority date is 2011 with my old employer. But my current employer is about to file perm in 2 or 3 weeks. So if let's say my current employer files my perm, and obviously it takes 6 months. Meanwhile, my previous employer files my I-485, and if I get my EAD within these 6 months with my previous employer, at that time I have to go to my previous employer, or can I wait until my current employer perm gets approved and then...
Okay, so you have to make a decision right now. You have to decide whether you want to work with your old employer or work with your new employer. You cannot sit in between, which is what you're doing right now. What you need to do right now is move to your old employer, file through them I-140, 485, start working for the old employer. Then after you're allowed to switch, then you can switch after 6 months to your new employer. The perm filed with the new employer is no longer useful in any way to you.
The next question from the number 0928, California number 0928 ending.
Hi, yes. Can you hear me?
Yes, please go ahead.
Yes, can you hear me?
Yeah, go ahead.
Shanti, quick questions. One is, once we file the 140 and I-485 concurrently, typically what is the time frame to get the EAD? And is there 6 months, or it can be much longer? Have any suggestions on that?
We don't know. Now it's 1 to 3 months, but obviously when they get thousands of applications, we don't know. It becomes a situation where we don't know because this hasn't happened before. So you have to continue on your H1 status until you get the EAD.
Yeah, next question is 5484 ending 5484, Maryland number ending 5484.
Yeah, hi, can you hear me?
Yes, please go ahead.
Yeah, thanks for the opportunity. Hi, Prashanthi, I have a couple of questions. The first one is regarding the interfile, right? So say someone downgraded from EB2 to EB3 and he got the EAD, he stick with the employer for 6 months, and after choose a different employer and worked on EAD. And at that point, let's say the EB2 finalization date became current. And that is when the interfile picture comes into, right? And interfile is something, based on my understanding, a beneficiary will directly appeal to USCIS, asking them to consider a previously approved EB2, right?
We can't hear you, Prashanthi. It's on mute. Looks like it's on mute. Prashanthi, it's on mute. Prashanthi, we can't hear you.
Can you please be concise and ask your exact question? We don't have much time.
So basically, what I'm trying to ask is EB2 downgraded to EB3, and the employee worked with the employer for 6 months and later on left, right? Because the 180 days that time frame has passed. And after the employee has left the company, the EB2 final action date became current, right? But at that point, the previous employer withdrew both the I-140 petitions from USCIS, both the EB2 and EB3. So basically, my question is, how can we interfile with USCIS, asking them to consider the previously approved EB2 if the employer has already withdrawn the I-140?
After 6 months, even if the employer withdraws, it's of no consequence. You're allowed to file AC-21 as per the regulations.
Yeah, next question ending 1888. We only have about 5 minutes. So next question 1888 ending.
Oh, hi. Can you hear me?
Yes, please go ahead. Be quick.
Oh, hi. So my quick question is that my passport is going to expire in November or this year. So is it going to be any kind of a problem for the documentation? I already applied for the passport, but
no, that's fine. You submit it with submit it with the submit it with the passport that you have, and if they require, they will ask for your renewed passport, and then you can submit it at that time.
The next question, Swati ending 6981. Swati ending 6981.
Hi, can you hear me?
Yeah, go ahead.
Okay, my quick question is regarding the name of my parents. So my birth certificate has a different name of my mom versus what's on the passport. How do we rectify that? Like, what else documents do we need to submit?
Is the name misspelled?
My mother's name is different. No, the names are totally different.
Then you have a big problem. How you can't have a different name for your mother's birth certificate.
Okay, the next question ending 3113. Next question ending 3113. Texas number.
I guess just to answer that previous question, sorry. You need to get it corrected from the authorities. Get that birth certificate corrected.
Yeah, misspelled is kind of fine, I believe, right?
It's
but
fine, but he's talking about a completely different name, so I'm a little confused.
Yeah, that's what I mean. To be clear, misspelled of parents' names are kind of fine. You can probably provide additional documents, but completely a different name is a trouble.
Is a problem, get it corrected.
The next question ending 3113 Texas. 3113 Texas. Texas number.
Hi, good afternoon, Prashanthi.
Yeah, go ahead.
I think you already touched base, like, you're able to hear me?
Yeah, go ahead.
Yeah, you already touched base on like spouses being in India. They have to come back for filing the 485. So they have to be here. They have to be here at the time of filing. Can you just touch base on those things?
Yes, they have to be here at the time of filing.
Yeah. Next question ending 8798. We only have a couple of minutes. Next question ending 8798.
Hello, Prashanthi. My name is Dean Rathod. So I'm working with the employer who filed my firm. Only problem is that I'm on a different location, which is a client's location, than the location on the firm. So do I have to move back to the location on the firm at the time of filing, or can I move later?
Okay, I think I heard that. He's talking about location problem, but in your perm, why would there be? So if you're a consultant, then obviously the perm will be filed from your employer's primary work location. If your employer has completely changed his address, then it could be a problem because you'll have to refile your labor cert and I-140 because the market was not tested for that work location.
What if it's within the MSA?
If it's within the MSA, then you can justify that.
Yes, it's a follow-up. Okay, the next question is from number ending 3163, Virginia number 3163. Please be quick. We only have a minute or two. Then.
Yeah. Hi. Thanks for taking my question. My question is, me and my wife both are working on H1 through two different companies. Both of our priority dates are current in EB2 and EB3. So how should we proceed now? Can we both apply separately, or she can be beneficiary on my application and I also can be a beneficiary on her application? So this is
Yeah,
my
you
question.
can, that's up to you. You can either file separate applications or just file the EB3 application, and one can be the dependent on the other. If you think there is some issue that with the application that one of you is filing and you think that it might get denied, then you file two 485 applications. That's you need to make that decision.
Okay, the next call ending 8689. 8689. We have hundreds of callers. We only have.
Yeah, I think this is the last call.
Yeah, last call. Yeah, we have to go. This 8689. Are you there?
Hey, Prashanthi, it's Rahul here. Can you hear me?
Yeah,
yes.
Go ahead.
Yeah. So, Prashanthi, I had a EB3 140 approved, and then it got upgraded to EB2. So I have both the 140s approved. When I when I do a downgrade right now, do I technically have to reapply for a 140, or is it like?
Now, why should you reapply if you have an EB3 I-140 is already approved, right? You already have it. So use that EB3 I-140 instead of using the EB2 I-140 and file concurrently the 485. I mean, file the 485.
Q&A session is over.
All right. Thanks a lot. Thanks a lot, Prashanthi.
Yeah, we are at the end, so almost done with the calls.
Hello.
Can you please?
Can you hear me? I have a question. Hello. Hello.
Oh, one second.
Hello.
We are already out of time. So
Q&A session has started.
we're already out of time. So thanks everyone for the call. We'll see if we can plan another session. We'll let you know. We have, I think, hundreds of calls waiting and we don't have much time. I'm sorry we had some technical issue. We'll make sure that it's not repeated. We'll see if we can plan another section and we'll keep you updated. We sincerely thank Prashanthi Garu for taking your time and helping the community. I know you are very busy, especially at this point of time, but I really appreciate, and Immigration Forum and all the callers are very appreciative of your take on helping the community and being always forward. Anytime anyone asks, you are always available. So we really appreciate whatever you have done. If you want to quickly include a conclusion, please go ahead.
I just wanted to say thank you. I'm really exhausted at this point because I've been doing this for not just this session, but I've been doing many sessions and also continuously taking calls and emails from the last 2 days, not including today. So please bear with me, and excuse me if my answers were brief, but I'm just very exhausted at this point and still trying to answer your questions, as efficiently as possible. So again, thank you for being such great listeners, and it was a pleasure being on this show.
Thanks everyone. Again, I just want to conclude. Immigration Forum brought to you this one. It's a national grassroots advocacy non-profit organization which is working to bring the fairness in high-skilled immigration system in our country. They are striving to get the new bills passed so that the immigration becomes fair. Thanks Immigration Forum for hosting this show. Thanks Prashanthi Garu. We had a great time. Again, we'll see if we can plan another one and we'll let you know. Thanks again. Thanks for your time, and thanks all the callers. Thanks so much. This recording will be on live, so you can always listen. Most of the questions are